Morning and welcome to our ChamberLIVE Looking Forward and Planning for the Future webinar. This webinar is delivered in partnership with Wright Hassall and we are joined by the lovely Caroline and Elizabeth from Wright Hassall. So throughout the next 35 to 45 minutes, they're going to be talking to you about the importance of a thorough financial stocktake, financial risk for directors, the end of temporary measures introduced by government to support businesses through the pandemic, and the options available to financially distressed businesses. So if you do have any questions throughout the presentation, do feel free to pop them in the chat box. And we are also going to do a little Q&A session at the end. So if you want to hold on to them and ask them to Caroline and Elizabeth yourself at the end, then you are more than welcome to do so. So what I'm going to do is I'm going to share my screen and then hand over to these two lovely ladies.
Thank you and good morning. We are delighted to be joining you this morning. My name's Caroline Benfield. I'm a partner at Wright Hassall and I also head up the insolvency and restructuring team at the firm. And I am joined today by my colleague Elizabeth Taylor, who is a consultant within the team. Liz and I have worked together for a large number of years. We have collectively over 45 years of experience in all matters concerning corporate and personal insolvency. So as I say, I'm delighted to be speaking to you today, and we are going to give you an overview of some of the issues we believe that business owners, directors and businesses should be considering at this time. So the coronavirus pandemic, as you all know, has created unprecedented challenges for businesses over the last 15 or so months. As businesses start to look to the future, important decisions will have to be made about the size and shape of business going forward. In many cases, accrued rent arrears and government-backed loans may have rendered companies' balance sheet insolvent. And in these circumstances, directors must act to protect the interests of creditors. Now, the statistics show that corporate and personal insolvency matters have consistently been down during the pandemic compared to previous years. But this is due to the financial support that's been available to companies and individuals and the temporary measures that were brought in to prevent creditors from pursuing their claims through the insolvency courts. However, the pandemic will inevitably affect insolvencies as the measures are lifted in the autumn and the support withdraws. All the signs, unfortunately, point to a tough road ahead. And today we're going to give you an overview of key considerations for directors during this uncertain time. Now, each of these topics that we're going to talk about could form the basis of a webinar in their own right, but I hope that what follows will provide a useful checklist of some of the most important factors to consider. Now, what underpins the practical advice that we're going to provide, and what's important to understand from the outset, is that a director must act in a way which they consider in good faith would be most likely to promote the success of a company for the benefit of the members as a whole. Now, the term success generally means an increase in the value of the company, but a director needs to decide in good faith whether it's appropriate for the company to take a particular course of action. And clearly the pandemic adds another dimension to this, not least because it is impossible to predict what impact this will have on the business. Now, when acting in a way they consider would be most likely to promote the success of a company, the director must have regard to a number of issues, and that includes the likely consequences of any decisions in the long term, the interests of the company's employees, and the need to foster company business relationships with customers and suppliers. However, the list isn't exhaustive, and directors will have to have regard to other matters which are relevant to the duty to promote the success of a company. So when taking advice from professionals on the options that are available to a business as we exit COVID-related restrictions, a whole range of matters, issues and circumstances will be considered, such as financial forecasting and projection, who the key stakeholders are and what the engagement levels are or have been with those stakeholders, any issues with getting staff back from furlough and whether pre-pandemic staffing levels have been reduced or will need to be reduced, the extent to which debt has been built up over the last year or so, and how those debt levels are going to be serviced, or the requirement for refinancing and restructuring. These are some of the issues that we're going to touch upon today. So against this backdrop, I'm going to now hand over to Liz, who's going to start running through some of the key considerations that directors should be thinking about. Thank you, Liz.
Forget to unmute. Thank you, Caroline. And as Caroline said, what follows is an overview of the steps that can be taken to ensure that businesses are in the best possible position financially and that directors are protected from criticism for the decisions that they have taken during the pandemic. So first of all, we're going to look at financial reporting, forecasting and decision making. It's essential to create a business plan, a cash flow forecast and to keep up-to-date management accounts. You'll need these for any negotiations with stakeholders such as landlords, lenders and suppliers to satisfy stakeholders and yourself that the business is viable going forward. These documents should be reviewed and updated frequently because we're still in a very fluid situation and businesses need to be agile in dealing with that. If you're going to be asking your landlord to vary the terms of the lease in any way, including reducing future rent or writing off arrears, you're going to need to be able to demonstrate why this is necessary. It's also essential that the board works together against a clear plan. Regular board meetings should be held and all decisions and the reasoning behind them need to be carefully documented, including any dissent and the reasons for this. You should record all sources of information that may not be available in the future, taking a screenshot, for example, where printing may not be an option. And this is because if the business fails for any reason, the liquidator or administrator is under an obligation to conduct an investigation into the causes of the company's failure and the conduct of the directors. In the context of such an investigation, the directors may need to justify any decisions that they took, and decisions can be easily justified if contemporaneous records are taken and kept. If the insolvency office holder is critical of the conduct of the directors and the directors are unable to justify the actions that they took, they could face proceedings for misfeasance or breach of duty by causing loss to the company. Relief from liability might be available if a director is able to demonstrate that he acted honestly and reasonably and the circumstances of the case mean that it's fair to excuse him from liability. But it's going to be a lot easier to demonstrate that you acted honestly and reasonably if you can provide contemporaneous evidence of your decision-making process and documentation, showing why you took the steps that you did at the time that you did and why you believed that you were acting in the best interest of the company. Now, the fact that a business fails does not automatically mean that the directors were at fault. Likewise, a decision may prove to be the wrong one with hindsight, but at the time it was made and based upon information available at the time, it seemed like the right decision. And this is why it's important to document the reasons why decisions were made. With regard to future funding, often self-help is a good start. And so consider your options for cash utilisation. For example, do you need external funding, or can you wring out any cash from your existing debtor ledger or stock? Do you have any old stock that isn't shifting? And if so, it might be possible to auction this off to generate some cash. Once you've considered your options on that score, then consider what financing you need and what for and how it's going to be utilised, and make sure that any money you obtain is then utilised for that purpose. Consider the pros and cons of debt versus equity. In other words, should an approach be made to your shareholders for an equity injection, or is external borrowing more appropriate? For those businesses who took out a C-bills or a bounce back loan, you'll need to consider the terms of repayment and the effect of this on cash flow. It would also be prudent to consider whether these are now fit for purpose or whether refinancing should be considered, provided that the company can demonstrate that it has the ability to service the debt. With regard to the CBILS loan scheme, the application process closed in March 2021, and it might be appropriate to consider whether at some point in the future it's possible to restructure that loan with the lender. With regard to the bounce back loans, the Chancellor announced in September 2020 the Pay As You Grow initiative, whereby businesses can request an extension of their loan term to 10 years from 6 years at the same fixed interest rate of 2.5%. However, thought needs to be given as to whether or not a 10-year loan term is something that the business wants to be saddled with, compared with other refinancing options that might be available. So if we could have our next slide, please. I'll talk about rent and your dealings with your landlord. So, as you may have heard on the news recently, excuse me, the government has recently extended the moratorium against forfeiture by landlords of commercial tenants. Currently, forfeiture of leases by way of legal proceedings or peaceable re-entry due to non-payment of rent is prohibited until the 25th of March 2022. Whilst this moratorium is in place, a landlord will not be able to evict a tenant for non-payment of rent. However, this doesn't stop rent being payable, and once the legislation has lapsed, a landlord will be able to claim for forfeiture for both payments that became due during the moratorium period and for any rent becoming due but unpaid after it ends. Because of this, the government announced on the 16th of June 2021 that it intends to introduce legislation to ring-fence arrears for periods where the tenant has had to remain closed during the pandemic, but not for periods during which the tenant's trading capacity was limited. At least that's what they've announced so far. The legislation will help landlords and tenants work together to come to an agreement on how to handle the money which is owed, and landlords are expected to make allowances for the ring-fenced arrears and share the financial impact with their tenants. If an agreement can't be reached for whatever reason, then the legislation is going to provide for a binding arbitration process to enable both parties to come to a formal agreement. This will be legally binding, and as such, both parties will be required to adhere to it. But because the draft legislation has not yet been published, we can't at this stage provide any more detail on its scope or how it's going to work in practice. In the meantime, the government has made it clear that tenants should pay rent where they're able to do so. And with regard to businesses such as nightclubs and other hospitality businesses, they should pay rent as soon as the restrictions change, which we now know is going to be from the 19th of July, and they're allowed to open. Where this is possible, there are good commercial reasons for doing so, because accrued rent arrears will show as a debt on your balance sheet, and this may affect your negotiations with stakeholders, where you're required to provide financial information for the purpose of your negotiations. In addition to the moratorium on forfeiture, the limitations on the use of commercial rent arrears recovery, known as CRA, have also been extended until the 25th of March 2020. The Taking Control of Goods and Certification of Enforcement Agents Amendment Coronavirus Regulations 2020, bit of a mouthful, were introduced in the spring of last year, and these prevented landlords from using CRA unless an amount of rent of at least 90 days was due, and that's an increase from the original 7 days. And from the 24th of June 2020, that was increased to 189 days rent under the amended regulations. And from the 16th of September 2020, the requirement was increased to 276 days outstanding rent. This rose to 366 days for enforcement notices given after the 24th of December 2020. And under the most recent extension to the restrictions, that amount has been increased to 554 days as at the 24th of June 2021. So obviously that significantly hampers the landlord's ability to use that process. So where rent has not been paid during lockdown and you're now in a position to pay some rent, you should take steps to engage with your landlord and negotiate with the landlord regarding the timing and payment of any arrears and future rent. Engagement with your landlord is very important, especially if you consider that in order to be able to trade through the current difficulties, you require a waiver or a deferral of rent. Arrangements with landlords can be either informal or formal, and ideally you want to get to a consensual arrangement. Otherwise, this might leave you having to consider formal procedures, including a formal insolvency process. Significant changes have taken place in the way that rents are being approached, and you may have seen on the news some recent high-profile company voluntary arrangements, including the likes of New Look, where store rents have been linked to turnover. A possible option might be to seek a rent reduction in return for a break clause, offering the landlord a break so that they have the ability to end the arrangement if they consider the terms to be no longer attractive. I've already mentioned the merits of paying rent to avoid accruing a debt on the balance sheet, but of course this needs to be weighed up against the cash flow implications of making monthly or quarterly rent payments. You should also consider whether your rent per property is sustainable going forward. And if it becomes apparent that premises are no longer required or sustainable, then you should consider invoking break clauses within the lease if the lease still has a considerable period left to run. In some circumstances, the landlord may already have taken the rent deposit against arrears. And if this hasn't yet happened, you may want to consider asking the landlord to do that without seeking a top-up of the deposit. If the landlord has already taken the rent deposit, you'll need to factor into your cash flow projections the possibility that he might require you to replenish it. It's important to remember that the landlord is unlikely to want the premises back at this stage, and this puts the tenant in a relatively strong bargaining position. However, engaging with your landlord is important to avoid action being taken once the moratorium and the stays are lifted. And as we've mentioned above, a landlord will almost certainly want financial information and forecasting from the tenant in order to assess and evaluate any proposals. So if we could move on to the next slide, please, to look at contracts with suppliers and customers. As has always been the case, cash is king, and so you should try to minimise all outgoings and review all contracts with your suppliers and customers. Where possible, you should seek to shorten customer payment terms, and internal credit control systems should be put in place to ensure that these are adhered to. This is going to require someone in your organisation to act as a credit controller with the necessary systems in place to ensure that action is taken quickly if payment terms are not adhered to and credit terms are not extended beyond those contained within the contract. Engaging with all stakeholders is important, and this includes suppliers of stock. Whilst you can consider extending supplier payment terms, the danger here is again that you'll start to incur debt on the balance sheet that the company can't subsequently discharge. And this means that you need to carefully consider whether extending supplier payment terms is going to lead to the business becoming insolvent on a balance sheet basis, meaning that liabilities exceed assets. This will have a bearing on the duties of the directors and also emphasises the point I made earlier about the importance of having an accurate cash flow forecast and management accounts. So at this point, I will hand you back over to Caroline.
Thank you, Liz. Okay, so you may be aware that on the 25th of June last year, the Corporate Insolvency and Governance Act of 2020, so CIGA, received royal assent and came into effect on the 26th of June. Now, that covered a whole range of things, but also introduced the disapplication of rights of a supplier to terminate a contract as a result of a company's insolvency. Now, many commercial contracts for the supply of goods and services contain clauses, and they're often referred to as ipso facto clauses. And they allow termination of a contract in the event that a party enters into an insolvency proceeding or procedure, or sometimes even if that action is just threatened. And typically a supplier would refuse to continue supplying the other party in an insolvency situation, and would often use that clause as leverage to try and obtain payment of previous debts. There had been increasing concerns raised that these clauses prevented those in financial difficulty from engaging in any meaningful insolvency procedure, as the contract could simply be terminated in such an event. So the policy intention behind the new provisions was to help companies trade through a restructuring or insolvency procedure and to maximise the opportunity for rescue of the company or the sale of the business as a going concern. The previous law already provided some protection for insolvency companies against certain suppliers who provide essential goods and services, for example, utilities. But CIGA now broadens the scope of the restrictions to a wide range of suppliers. The new provisions under CIGA apply where a company becomes subject to a relevant insolvency procedure, and that includes things such as administration and liquidation. And they state that a provision in a contract for the supply of goods or services ceases to have effect where a company becomes subject to an insolvency procedure if under that provision the contract or supply would terminate because the company has gone into an insolvency procedure, or the supplier would be entitled to terminate or do any other thing because the company has gone into an insolvency procedure. So this effectively means that there is a prohibition on the reliance by suppliers on termination clauses in contracts for the supply of goods or services that are triggered when a party has entered into a formal insolvency procedure. The provisions also mean that where under a provision of a contract for the supply of goods or services, the supplier is entitled to terminate the contract because of an event that occurred before the start of the insolvency period, and that entitlement arose but wasn't triggered, then the entitlement may not then be exercised during the insolvency procedure. However, for breaches that aren't connected with a company's insolvency, which happen after the insolvency procedure begins, the suppliers will be allowed to terminate. A supplier is also able to terminate if the company or the office holder consents, or if the court is satisfied that the continuation of supply would cause the company hardship. However, unfortunately, hardship isn't actually defined in CIGA, and that will ultimately at some point have to be resolved potentially by the courts. What is also built into the provisions is a restriction for a supplier to require pre-insolvency debt to be paid as a condition for making further supplies. And the new provisions apply where the insolvency procedure commenced on or after the 26th of June 2020, and they apply in respect to contracts entered into before as well as after that date. You may well have been aware that before the 30th of June this year, there was a temporary exclusion for small suppliers, and that was based, small being based on turnover, balance sheet, number of employees. So there was an exclusion for small suppliers who had supplied to a company that had gone into an formal insolvency process, which meant that those provisions did not apply. However, those exclusions expired on the 30th of June. Therefore, the restrictions now apply to all companies. Sorry, apologies, my kitten has just decided to jump up at me. So in light of these changes, there are a number of considerations which should be taken when entering into a new contractual arrangement with customers, which actually are probably outside of the remit of today's talk, in a respect of which I would suggest that advice and guidance is sought from a commercial contract lawyer. But on a practical level, there are a number of things that a supplier may want to consider, and that includes conducting deeper due diligence on customers' financial position before entering into contracts, and actively monitoring customer payment performance and their financial position. Ensuring that you have a good working knowledge of at least the customer contracts, so being familiar with the rights and show if there are any signs of financial distress, ensuring invoices are paid when due, and if necessary, tightening debt collection procedures. And being ready to promptly exercise contractual rights to stop the supply or termination of a contract promptly when you can, when a customer is starting to show signs of financial distress. And then just continually reviewing your standard terms and conditions and making sure that they protect the supplier against a customer's insolvency so far as it is possible to do so. So if we could move on to the next slide, that's going to take me to employees and furlough. Thank you. So the coronavirus job retention scheme, as I'm sure you're all aware, has been extended until the 30th of September this year. Now, from the 1st of July, businesses are being asked to contribute towards the cost of furloughed employees' wages. The government will pay 70% of wages up to a maximum cap of £2,187.50 for the hours the employee is on furlough, and employers are being required to top up employees' wages to make sure they receive 80% of wages up to £2,500. And claims for furlough days in June 2021 need to be made by the 14th of July. What is really important when considering employees and furlough is that you carefully consider future staffing requirements and that you act early and foreplan. Realistically, a business may have a reduced turnover and may not require all of its existing staff. So the sooner that redundancy consultation begins, the sooner the business can move down in a slimmed down form. But you do need to bear in mind, obviously, that redundancy can be an expensive option and can have a significant impact on cash. So you therefore need to feed in the cost of redundancy into your cash flow and P&L in order to ensure that you understand what the picture looks like. What is also really important is not to assume that all of your workforce are going to return from furlough when they're asked to do so. You might find that your employees have found work elsewhere, and we are aware at the moment of restaurants, bars, pubs suffering from staff shortages, where employees have obtained employment elsewhere and have no intention of returning to their previous employment, especially if it pays less and requires them to work unsociable hours. So it is important to engage and communicate with your staff in order to understand what their intentions are. Consider whether, for example, you should make use of the flexi furlough scheme, because that, when you ask them to come back, albeit on a part-time basis, that might provide you with a clearer idea of whether you have a loyal member of staff. What then is an important aspect with furlough, is to consider whether you have operated the furlough scheme correctly, or whether you are no longer entitled to keep the CJRS grant because circumstances have changed. So, for example, you've continued to receive the grant from an employee after they left employment. Businesses that have received the grants that they're not entitled to must report to HMRC and pay back sums incorrectly received within 90 days after receipt of the grant. Self-reporting will protect a business from financial penalties that HMRC may impose. If the business fails to self-report within the 90-day window, they'll be liable to a fine on the basis that the wrongdoing, potentially that the wrongdoing was deliberate and concealed. The penalty range is a minimum of 30% up to a maximum of 100% of the sums received on top of the repayment of the CJRS grant. However, where HMRC can prove that a business intended to commit fraud, it will consider criminal charges. And in those circumstances, self-reporting is not going to protect the business from those sanctions. And you may recall that in March, the Chancellor announced the creation of a task force to tackle fraud within the furlough scheme, and that £100 million has been invested, is going to be made available to enable the task force to crack down on those who defraud the COVID-19 government support initiatives, including the coronavirus job retention scheme. For those businesses, so I repeat really, for those businesses that have taken advantage of the furlough scheme, it's imperative that you undertake an audit process now in order to check whether you've got it right or whether you've made any mistake. And if a mistake has been made, then the right disclosures will need to be undertaken, and therefore early engagement with HMRC is key. So that actually neatly then takes me on to Crown debt. So if we could move on to the next slide, please. So with Crown debt, you'll recall that in order to support businesses during the pandemic, the government announced on the 20th of March last year that certain VAT payments could be deferred. And it applied to payments due between the 20th of March 2020 and the 30th of June 2020. And businesses were initially given until the 31st of March of this year to pay any liabilities which had accumulated. Now, to cut a very long story short, businesses were then given the option to either pay the deferred VAT in full on or before the 30th of this year, so the 30th of June 2021, or to sign up to the new payment scheme, or to contact HMRC by the 30th of June of this year if they needed more help to pay. And failure to take one of those steps may result in a penalty being charged of 5% of the deferred VAT outstanding if the business did not opt into the new payment scheme or pay in full, make some other arrangement to pay by the 30th of June this year. As such, if you've not taken the steps you should have done by the deadlines which I've just mentioned, then it's important that you seek advice and engage with HMRC at the earliest opportunity. Whichever option you have opted for, you'll also need to factor into your cash flow. So extensions to time to pay arrangements will have been dealt with on a case-by-case basis, but you'll need to make provision in your cash flow for payments to resume. Now, turning to pay to time arrangements, we understand that some of those have been agreed with HMRC over the telephone, and nothing as yet has been confirmed in writing. We're aware that this has created problems for some businesses who are, for example, assessing options for refinancing as part of the funder's requirements. They require the agreement which is being reached with HMRC to be properly documented in writing. We understand that this has created some logistical issues with HMRC not sending letters out initially. But if you explain the situation to HMRC and the requirement for you to have something in writing, they will oblige, but we understand that the time frame for providing that letter can be variable. But HMRC should be fully alive to the fact that businesses are going to need to access finance. And in turn, that's going to require certainty on what needs to be paid to stakeholders and when. Now, something which you might not be aware of, but because it's a recent publication, but HMRC published on the 30th of June a policy paper. And that paper has announced that HMRC is going to restart its debt collection work as economic activity resumes and following the gradual easing of restrictions in the UK. The paper in brief says that HMRC is going to be contacting all customers with tax debts with a view to arranging for payment as quickly as possible, where necessary, agreeing time to pay arrangements, visiting taxpayers who ignore HMRC communications or refuse to pay their taxes. And from September 2021, they're going to resume use of their enforcement powers, including seizure of goods and insolvency proceedings. Now, they do say at all times that they're going to take an understanding and supportive approach and that they will use their enforcement powers fairly and carefully. But it would appear that the threat to visit premises and use enforcement powers applies to those taxpayers who fail to respond to communications from HMRC and refuse to put forward payment proposals. So this reinforces the message that it's vital to engage with HMRC as early as possible if you are concerned about your ability to settle Crown debts. So I'm now just going to quickly pass back to Liz, who's going to touch upon some of the temporary measures that are contained in SEGA. Thank you, Liz.
Thanks, Caroline. So as Caroline explained, the SEGA 2020 came into force on the 26th of June 2020, and this introduced a number of temporary measures designed to mitigate the effects of the coronavirus pandemic on businesses. And one of those measures was that it became impossible to present a winding up petition based upon non-compliance with a statutory demand served between the 1st of March 2020 and the 30th of September 2020, and a winding up petition cannot be presented upon any ground between the 27th of April 2020 and the 30th of September 2020, unless it satisfies the new coronavirus test. Those restrictions have been extended on numerous occasions, and most recently, in the middle of June, they were extended until the 30th of September 2021. And it means that in order for the court to allow a petition to proceed, a creditor has to satisfy the court that the reason the debtor can't pay the outstanding debt has got nothing to do with coronavirus. Now, this is obviously double-edged, this measure, depending upon whether you're a creditor or a debtor, because from a debtor's perspective, it's clearly positive because the judge will simply dismiss a petition if he or she believes on the evidence that the debtor's inability to pay the debt is coronavirus related. However, from a creditor's perspective, the threat of winding up proceedings as a tool to extract payment of an overdue debt has now been removed until the expiry of these measures. So whilst the prohibition on winding up proceedings is temporary, as I've mentioned above, it's been extended on a number of occasions and it's currently due to expire on 30th of September 2021. But built into the legislation is the ability for the expiry date to be extended so that it could be extended at short notice, and it remains to be seen whether it will be further extended until March 2022 in line with the moratorium on forfeiture of commercial tenancies. I suspect that much will depend upon the spread of the virus over the summer months, although, if has just been announced, all restrictions are going to be lifted on the 19th of July, the government may find it hard to justify a further extension beyond the 30th of September 2021 in order to balance the interests of creditors and debtors. So watch this space. The Act included another temporary measure designed to mitigate the effects of the pandemic, which was a suspension of the wrongful trading provisions in the Insolvency Act 1986. A claim for wrongful trading arises where a company goes into insolvent liquidation and the liquidator forms the view that the company ought to have ceased trading at an earlier point in time. And if the company's balance sheet position deteriorated between the point that it should have ceased trading and the point that it actually ceased trading, the liquidator can seek a contribution from the directors personally towards the increased deficit position. However, CIGA 2020 introduced a temporary suspension of the wrongful trading provisions, such that originally a director could not face liability for wrongful trading from any conduct which took place between the 1st of March 2020 and the 30th of September 2020. That period was then extended until the 30th of June 2021, but no further extension was announced when the other temporary restrictions were extended recently, such that the suspension of the wrongful trading provisions expired on the 30th of June 2021. It's therefore important for company directors to recognise that their ability to rely on the suspension of the wrongful trading provisions and any comfort that they derived from this has now expired, such that directors could face personal liability for decisions to trade on beyond the 30th of June 2021 if the company subsequently goes into liquidation or administration. And this underlines the importance of carefully documenting all decisions, as I talked about earlier. It's also important to emphasise that all other directors' duties under the Companies Act 2006 have remained in place throughout the pandemic, and these include acting within your powers, exercising independent judgment, promoting the success of the company, exercising reasonable care, skill and diligence, and avoiding any conflicts of interest. However, if at any point you've got reason to believe that the company is insolvent, either on a cash flow or a balance sheet basis, advice should be sought from an insolvency professional at the earliest opportunity, because taking and acting upon such advice will assist in deflecting any accusation that you fail to act in the best interests of the company's creditors. It may be possible to put together a restructuring plan or a company voluntary arrangement if the business is thought to be viable going forward. And CIGA 2020 introduced a new moratorium process for businesses in this position. And this provides an initial breathing space of 20 days, which can be extended, during which no enforcement action can be taken against the company whilst it explores a range of rescue options. And so I will now hand you back to Caroline.
Thank you. So the key message from all of this is to get the right advice at the right time. For a lot of businesses, assets have depleted, whereas the debt has increased. And as such, taking advice from the right professional advisors at the right time and keeping detailed notes of that advice and the decisions which have been taken and why is extremely important. It remains difficult, extremely difficult to predict how this is all going to play out. But we hope the guidance that we've provided has been useful in providing an overview of some of the key considerations for directors and business owners during this difficult time. So I'm now going to pass back to Cheyenne, who I understand is going to be inviting questions. Thank you.
Lovely. Thank you both so much. That was brilliant. I am just going to stop sharing my screen. Perfect. So we have had a question in the chat from Wendy. She's said if they do not want to return after furlough, do they resign? Do they get paid notice, etc.? Oh, you're on mute, Liz.
Classic. I'm not an employment lawyer and neither is Caroline, but my understanding is that the furlough scheme has not affected employment contracts in any permanent way. And so if an employee doesn't want to return at the end of the furlough scheme and they want to hand their notice in, then the normal notice requirements under the terms of their contract would apply and they would have to work their notice. That's my understanding of the position, but as I said, I'm not an employment lawyer, but I'm not aware that the fundamental principles of employment contract law have changed.
Lovely, thank you. And Wendy said thank you as well. Does anybody else have any questions? Do you feel free to raise your hand, and we can obviously make it so that you can ask questions directly to Caroline and Elizabeth. But in the meantime, while we wait, just a couple of questions from me, if that's okay, for Liz. So what are the chances of furlough being extended beyond September 2021?
Well, my view on that, based upon the announcements which Boris Johnson made this week, is that that's extremely unlikely. I think the government has sent a very strong message that they would like business to return to normal or as near to normal as quickly as possible. And, you know, Caroline touched on the position within the hospitality industry in her presentation. You know, the fact that those businesses are really struggling to get staff, because a lot of staff are on furlough at the moment. They don't want to come back. Most of those staff are young people and therefore at the moment most at risk, and perhaps they don't want to be in a busy environment and putting themselves at risk. So they don't want to come back to work, but they're going to have to come back to work if businesses are going to get back to normal. And we need hospitality, pubs, restaurants, clubs to be back at full capacity to aid the economic recovery. And I think for that reason, I think the government will say no. I think it won't be extended beyond September. That's my view.
Lovely, thank you. And also for Caroline, just a quick one. So who should businesses be going to identify, you know, if their business is in trouble or if they might be facing solvency issues?
Okay, so as I think we've repeated throughout the talk, that it's really important to take advice at an early stage and to document that advice. And that advice should be, first of all, taken from insolvency professionals. So you could come to the likes of Liz and I, who are insolvency lawyers within a firm, but we often work very closely with insolvency practitioners. So we will bring in insolvency practitioners who will be able to then look at the financials of that business and advise on the various options that might be available for a business. And that might not necessarily be an insolvency and a drastic form of insolvency. It could be some form of restructuring, you know, to enable the business to carry on in some shape or form. You know, you can just go straight to an insolvency practitioner for that. But quite often we combine forces, so they get the legal advice as well as the financial sort of accounting insolvency practitioner style advice, and that works quite neatly and quite well. But the key to it all is to take advice early, so that we can try and work a way through it, or at least guide them in the right direction before, you know, massive, huge issues arise. So yes.
Lovely, thank you both so much. Does anybody else have any questions that they would like to add?
We've obviously covered it so well,
yeah,
so clearly.
No one's got any questions. Brilliant. Well, just to say that if it's okay with you both, I will send a copy of the slides out to everyone who attended today. And I do believe that on the slides it has your contact details on there. So obviously if anybody does have any further questions following today's session, they are more than welcome to get in touch with Caroline or Elizabeth. And oh, Pam did raise her hand then, but then she put it down. So yeah, so I think that's everything today. So thank you both so much for joining us and presenting. It was really, really useful. And thank you to everyone who attended to hear from Caroline and Elizabeth today. So yeah, thank you all for attending. And like I say, I will pop a copy of the slides out to everyone shortly, later on today, more than likely. Perfect. Thank you all so much.